Each candidate will have a 3-minute initial statement and 1 minute for questions, and they will be timed, and if they're interrupted, it's because their time is up. We're going to begin with Timothy Cannon.
Thank you, Fran. Can everybody hear me, or is that better? Thank you, Fran, and thanks to the League for putting this forum together to give us all a chance to tell you a little something about ourselves. I'm Judge Tim Cannon. You're currently your judge on the 11th District Court of Appeals. I'm in my 8th year of service there as a judge, and in my 4th year as the presiding and administrative judge. I'm married, live with my wife of 34 years, Lisa, and we have 2 grown children. One of them is a firefighter and paramedic here in Ashtabula City. I have received in my time and my tenure as a judge many appointments and accolades from the Ohio Supreme Court. I've served as a visiting justice there on a couple of occasions. The Chief Justice put me in charge of a new case management committee to reformat the delivery of services from every court in the state of Ohio. I chaired that committee for 3 years. I've also been appointed to 5 other appellate districts to help out with their caseload. It's hard in 3 minutes to tell you everything we can about ourselves, but I would ask you to draw on a couple of things. Number one, 2 newspapers, 2 major newspapers in our district, it's a 5-county district, have endorsed in this race. Each of the newspapers has endorsed me and indicated I was the clear choice here. The bar associations in the 5 counties, 3 of them have conducted polls so far. And in 2 of those polls, the Portage County poll and the Lake County poll, I've been highly recommended by the bar associations. And in the Trumbull County poll, I was overwhelmingly preferred. Now, you may hear that you shouldn't believe what you read in the newspaper, and you should hear that we aren't here to please the attorneys, but I don't work to please the attorneys. I work hard, I know the law, I have a good judicial temperament, and the attorneys in a secret ballot, I can't get back at anybody if they don't vote for me, have indicated that they prefer to have me stay on the bench. And that's important because they know us. We don't work directly with the public the way your local municipal courts do and common pleas courts. We work primarily with attorneys. And the newspapers, well, you know, the newspapers do extensive interviews with us. There's extensive questionnaires and a chance for us to interact with them and feed back and forth. It's just been an honor and a pleasure to serve you as your judge on the 11th District Court of Appeals. I would be proud to serve another term. I believe I've done a good job, and that's been verified by the Ohio Supreme Court and the attorneys who work with our court. They know best if I work hard, and if I know the law, if I have a good judicial temperament, and if my decisions are based on the facts and not any outside influences. Thank you very much.
Thank you. Mr. Tamburrino.
Thank you, Fran. My name is Ron Tamburrino. I'm a candidate for judge on the 11th District Court of Appeals. I'm married to my wife, Leanne. We've been married for 21 years. We have 6 children. We live on an operating farm in Trumbull Township, and I'd be honored if you make me the 2nd Court of Appeals judge on the 11th District from Ashtabula County. The first was Judge Malone several years ago. I'm an elected township trustee in Trumbull Township, serving my 3rd term, and my wife is the president of the Sheridan Theater. My wife and I operate several small businesses. I graduated from the University of Akron with degrees in fire science and technical education, and continued at the University of Akron where I obtained my law degree. I've engaged in insurance fraud investigation businesses, primarily arson and business fraud, and I was in private practice in Stark County after I graduated from law school, doing a broad variety of cases, both civil and criminal, in state and federal courts. After 5 years in private practice, I joined the Sherwin-Williams Company's litigation section in their legal department, where I assumed positions of increasing responsibility over the next 26 years, the last 7 years of which I was in charge of all of the general litigation and appeals of the entire company. I had a practice of law that was national in scope. I received national awards. I didn't belong to local bar associations. And I think it's important to recognize that the breadth of experience that I've received over my career well suits me to be a judge on the 11th District Court of Appeals, both the breadth and the depth of experience that I have. A company the size of Sherwin-Williams Company, you can imagine, has its own manufacturing facilities, its own trucking companies, and a myriad of other business functions that gave me the broadest experience. In fact, my qualifications are the broadest of any judge that's ever been elected to the 11th District Court of Appeals. I believe that the Court of Appeals is a court for the people, not a court for judges. I believe that there are shortcomings on the 11th District Court of Appeals. The website is woefully inadequate, one of the worst of the 12 districts in the state. The budget should be posted so you know what the expenses are that the court is incurring. They're spending your money after all. Management issues at the court include lagging and delayed justice. Justice delayed is justice denied. The court cases in the Court of Appeals are not being turned out timely enough. This 11th District Court of Appeals has a bad reputation among attorneys in the state, and I'm the person that you should elect to turn that around. Those are business issues, not legal issues. I know the law. My opponent has had 60% of his decisions that were reviewed by the Ohio Supreme Court reversed on appeal. He doesn't know the law. Thank you.
Thank you. First question. When making a decision, is there a specific procedure you use in weighing the evidence on the record? Mr. Cannon.
Could you repeat that?
When making a decision, is there a specific procedure you use in weighing the evidence on the record?
Well, the part of that question that's a little confusing is the part that talks about weighing the evidence. We typically don't weigh the evidence. We review the record that is prepared and controlled in the trial court. And our review of the case is typically confined to whatever in that record. In the trial setting, there are a lot of determinations of fact that are made. Questions of fact, who had the red light, whether or not somebody sustained serious physical harm. Those questions of fact are usually resolved by a jury, or a judge if the case is tried before a judge. And we're typically confined by those findings of fact that are made at the trial court level. But the record that is before us is going to help us determine the cause. And the number of cases that are mine that are reversed from the Supreme Court is incredibly inaccurate and misrepresented.
Mr. Tamburrino.
Yes, in terms of the specific procedure, no, it depends on what kind of case it is. There are circumstances on direct actions where evidence has to be weighed in the first instance by the Court of Appeals. There are instances on appeal where the evidence has to be weighed because it's part of the appeal rather than an issue of error has been raised on appeal. In terms of the specific protocol, I don't think it's fair to say that there's a specific protocol because it depends on the nature of the case and the posture of the proceedings in the lower court. I'd also like to point out that I didn't specify a number of cases that my opponent has decided that have been reversed. I indicated that of all of the cases that he's decided that have been reviewed by the Supreme Court, 60% of them have been reversed by the Supreme Court. Thank you.
What is your feeling on merit selection of judges? Mr. Tamburrino.
I believe that merit selection of judges is a good goal. Other states have moved to merit selection rather than voting for judges. The merit selection process, it would be a lot more vigorous and credible than local bar associations voting on secret ballots and for newspapers. How many people believe and respect everything you read in the newspaper? I don't see any hands. So, it's bar association polls, newspaper endorsements. Merit selection would be a lot better. The problem is the merit selection process. Who do you involve? One of the groups that should definitely be involved are citizen representatives. And I believe that the Court of Appeals in the 11th District does a poor job of letting the public who pays their salaries and pays their bills know what's going on in the Court of Appeals. And if I'm elected, all of that information is going to be on the website immediately and forthwith. Thank you.
Thank you, Mr. Hannon.
I think there's a lot of good aspects to a merit selection process. The merit selection process should be independent, first of all. It shouldn't be political in any way. And there should be a way to ferret out what good qualified candidates are. Short of a merit selection process, we should consider what many other states do, and that is a retention election. If a judge is on the bench and doing a good job, he can run on his record rather than having to campaign. And you know, right now in Ohio, if you've got $50, you can get on, and you've been practicing law for 6 years, you can get on the ballot. And if you've got a name and a lot of yard signs, you know, you could possibly get elected without ever having any experience with the court that you seek to serve on. I don't think that's a good, healthy situation. The bar associations do those polls and the newspaper do those things for the people. They want the people to know. Thank you.
Thank you. What collaboration efforts are made between the judges to make good decisions? Mr. Cannon.
Well, we sit as a group of three, a panel of three, to hear and decide each case. The three judges in our court are scheduled for cases well in advance. And one of those three judges is assigned to be the primary writer for each case. When the case is ready to be heard, research is done by our clerks. We have discussions with each other. We have an oral argument typically, and at the oral argument we ask questions and ferret out issues that we see in the case that may not have been addressed by the attorneys. When the case is concluded, we conference each case at the conclusion of the case to determine whether or not we are all in agreement with the way the case should be decided.
Thank you. Mr. Tamburrino.
I don't disagree with anything relating to the procedure that Mr. Cannon just described. The only thing that I would add that I would strive to do differently is that when the three judges on the panel get together and debate the issues before oral argument, that if and to the extent they identify issues that the judges haven't raised in their briefs, that in fairness to the parties, not the attorneys, but in fairness to the parties, the judges should be contacted. And there's a procedural mechanism for doing that, to advise them that they have the right to submit a supplemental brief on some legal issue that's not presented in the briefs that are being reviewed. And again, that's something that I think needs to be done for the public and the parties in the case, not for the protection of the attorneys. The Court of Appeals has discretion to do that, and it's rarely exercised, and I think that's wrong.
Thank you. Candidates for 11th District Court of Appeals, 2915. Thank you, gentlemen.
Thank you.
For the candidates for the 11th District Court of Appeals,